Welcome to Rebel Chaser. My name is Gail, and I've got 5 videos for you tonight. The first one is with Judge Rossi. The second one is with Judge Nelson, and both of those videos have really smug women. I don't know what that is all about, but I'll let you guys watch that. Then there's one with Judge Tavera in Texas. Another one with Judge Boyd, where she's going to give a stern talking to, shellacking. And then the last one is, I don't know her name, but she's a judge filling in for Chisholm. And she gives a complete shellacking to a young woman. So I'll let you guys watch.
We are here in the case of Leah Fournier versus Melanie Gonzalez, case number 24-09587PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And today is the time and place set for hearing on allegations that the respondent in this matter, Ms. Gonzalez, violated this court's personal protective order. Counsel, would you place your appearances on the record, beginning with prosecutor's office?
Joseph Jackson, Kent County Prosecutor's Office.
Thank you.
Jeremy Byer, court appointed for Ms. Gonzalez.
Very good. Thank you, Mr. Byer. With that, Mr. Jackson, you may proceed.
Yes, Your Honor, thank you. I believe before the court are 2 separate PPO violation allegations. I believe there's one from December and then one from June of this year. We will be proceeding and taking testimony with regards to the PPO violation from June. We will not be proceeding or taking testimony with regards to the PPO violation alleged in December.
Very well. You may proceed.
With that, I'd like to call the petitioner, please.
Very good. Ms. Fournier, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, sir.
Thank you. You may proceed, Mr. Jackson.
Ma'am, would you please state and spell your name for the record?
Leah Fournier, Leahfournier.
And you are the protected party in a personal protection order against Melanie Gonzalez?
That is correct.
Okay. And did you file an affidavit in motion for show cause with regards to alleged violations of that PPO?
Yes, I uploaded everything with the court.
And is one of the first allegations that Ms. Gonzalez texted you and called you multiple times off of Brian's phone number?
That is correct.
Let's start with the text messages. Can you tell the court how she texted you and how you know she texted you?
Well, the father of my child and I, we have a really good relationship, and he would never speak to me that way. But throughout my entire pregnancy, she did nothing but harass me, stalk me, and threaten me that she was going to harm me and my unborn child. Hence why the PPO was initially approved. After the PPO was approved, rather than her texting me from her own phone, she would then harass me from Brian's phone. Brian does not text like that. He's not a texting type of guy. He'd rather just kind of call you. He also doesn't speak the greatest he doesn't type the greatest English nor speaks it. And he doesn't talk that way. He would never talk to me that way. At one point when Brian was dating Miss Gonzalez, it's just been nothing but drama ever since. She's harassed me, like I said, just months and months on end, and it just doesn't stop.
Do you recall any specific text messages that you know that she sent you? What they said or what they were?
Yep. I thought everything was uploaded with the court, so I thought you had those copies. He had texted me and was like, "Oh, if you want to fight, then let's go in a parking lot. Don't be a Karen and call the police." She just wanted to physically fight me.
Do you know when that text message is from?
I believe it was actually in September, late September.
Do you not have that with you?
I don't have it with me currently, no.
Your Honor, I would object to any testimony about late September. That was about the time that the court issued the PPO, so I believe those have already been adjudicated. I would ask that the testimony stick with just the June allegations.
Okay, and I do have a date that the order was signed here. I think it's September 28th. I'm uncertain of when it was served on the respondent, but I do have a signed date here, 9/28. I guess for purposes of the objection, I'll overrule it. I'll allow the testimony, but I will note the earliest date the PPO was even signed was 9/28. I don't know if respondent was even aware of it at that time. So, but I'm going to overrule the objection, allow Mr. Jackson to take the testimony. Mr. Jackson, you may
Thank you.
proceed.
So, right, were the text messages that you're referring to after or before the PPO was granted by the court?
Both. But I thought it was both after because, like he stated, it was signed September 28th. I don't know how soon that she was served. I got it served as soon as I could to her. I think it was like maybe a day or two after, so she's already aware of that. But after the PPOs were served, again, I continued to receive text messages from Melanie and calls.
Okay, so let's focus on the text messages and calls, but let's just start with text messages that you received after service. I have Your Honor, for the court's edification, I have looking at a copy of a proof of service in this case indicating service on 10/1/2020. Well, it says 10/1/24 at 6:18 p.m.
That's consistent with what I have in my file.
Okay. So let's talk about only text messages and calls after October 1st, 6:18 p.m.
Okay.
What can you tell me about text messages after that date?
She was just still texting me and calling me from Brian's phone because she knew that if she texted me or called me from her phone, it would be a violation. So she was trying to be slick with it and contact me from Brian's phone. Brian would never speak to me that way or let alone harass me that way and send me multiple messages. The only individual that I have an issue with is her. And it's been her since June of last year is when this all started.
In any of the text messages since October 1st, has she identified herself as Melanie?
In some of the text messages that I provided to the court, yes, she did admit that this was Melanie and claiming that I was a coward because I didn't want to fight her when I was pregnant.
Okay. And that was after October 1st?
Correct. The court should have copies of that. I uploaded everything and sent everything to Lauren as well. I know I was initially working with her. I didn't realize I needed copies of this myself. Otherwise, I would have had them in front of me. So I'm trying to go based upon memory here.
Okay. Do you recall her contacting you in May, thinking that she was talking to Brian? And correct me if I'm wrong, Brian is the father of your child.
That is correct.
Okay. And at one point he was in a relationship with her?
Correct.
Okay. So do you recall a time in May when she was contacting you as if you were or trying to get a hold of Brian?
I don't recall. I know she had wrote a physical letter to the father of my child, Brian, trying to contact him, which I don't know why. She wrote him a letter, so he then reached out to her over text, and I did provide those text messages.
Okay.
I think that was the most recent one, and the father of my child, Brian, did forward me every message, so I provided that. Ms. Gonzalez only provided some of them, not all of them. I'm not really sure why she had failed to do that, so I uploaded every single message that was forwarded to me by Brian.
Okay. Is there anything else or any other proof you have with regards to text messages in which she identifies herself or that you can prove that it's her other than the vernacular, how it's and or how it's being written that leads you to believe it's not Brian?
No, but like I said, this is the only individual that has been causing issues in my life and Brian's life. And she has a record as well. So that should be a red flag. She has assaulted someone.
Objection, Your Honor. I don't know how that's relevant or appropriate to bring up any past record of Ms. Gonzalez.
Response on the past record objection, Mr. Jackson.
Your Honor, I think it was relevant, but probably not responsive to the question.
Very well, then I'll sustain the objection. Ask you to move on, Mr. Jackson.
Thank you, Your Honor. Ma'am, let's move now to the phone call. Since October 1st, have you received phone calls from the respondent?
Yes, off of Brian's phone.
Okay. Do you know when that was?
I want to say closer to November timeframe. I got a call from Brian's phone, thinking it was Brian. He asked if he could speak with me. Initially, he texted me, and I stated that I don't want to talk to him if Melanie is nearby because I don't want the drama, and I also don't want to communicate with her for the PPO order that I had. Well, then when I got a call from Brian, I answered it, and it wasn't Brian. It was Melanie. And she was just going off on me over the phone, saying, again, how I'm a coward because I don't want to fight her. My sister was also right there when that had happened, and that is one of my witnesses. She is unable to be here today because she is currently in the hospital.
Okay. This phone call that you received, why did you answer it?
Initially, I thought it was Brian texting me at one point because he said, "Hey, can I call you?" And I asked him why. Why do we need to call? We only ever really communicated if it was about our daughter when I was pregnant, with our baby. And I just thought it was kind of odd. So when he had called me, he didn't call me once. He called me multiple times. So then I thought maybe something was wrong or something was urgent that he needed to speak with me about. And when I answered the phone, it was not Brian. It was Melanie.
Was this from a number that was saved in your phone, like under Brian? Like it was a known number? Or was it a number you didn't know?
Nope, it was a known number. This was Brian's phone at the time. So Miss Gonzalez had broke Brian's initial phone he had and then bought him a phone under her plan.
Okay. Do you know whether or not he and Miss Gonzalez were together or in a relationship at this time?
They were in a relationship at this time, yes.
Okay. Was he ever on the phone when she called you?
No. Nope, it was always her.
Okay. Did she identify herself, or how did you know it was her?
She identified herself and said, "This is Melanie," and said, "You're a coward. Let's, fight each other." And she just started going off on me. And then I didn't even respond. I just ended the call because I didn't want to deal with that.
How long did the call last?
Maybe like 2 to 3 minutes. Not long.
Okay. Well, what else was said during this 2 to 3 minutes? Because I think what you said just took about 6 seconds.
Well, initially I had heard her I don't know if Brian was in the background. All I could hear was her voice, but she was like yelling at him from what I think. And then she started going off on me. I don't really remember. I vaguely remember her saying, just like I said, let's fight, let's fight. Oh, you're not about it. Just continue to repeat herself over and over again about how we should resolve this, with a physical altercation instead.
What did you say when you were on the phone with her for this 2 to 3 minutes?
I had told her that she doesn't need to be speaking with me, to please stop contacting me from Brian's phone, and I then hung up on her.
Okay. Was this phone call up to your ear on speakerphone?
It was on speakerphone. Yep, and this was the phone call where my sister was sitting right next to me and heard every word.
Okay. Had your sister previously met the respondent?
She has never met her, but she knows of her from everything going on.
Okay. Were there any other phone calls from the respondent to you since October 1st of 24?
Not that I believe, no.
Do you have any other evidence to present the court today and to aid it in making its findings?
No.
Your Honor, I have no further questions of this witness.
Any cross-examination, Mr. Meyer?
Yes. You had mentioned that you had two different testimony I just want to clarify. In one of your testimony, you said that she was on the phone. And another one, you said she was in the background and Brian was on the phone. Can you clarify that for us?
So I stated that Melanie was on the phone and she was on Brian's phone calling me. When I initially answered the phone, I do not know if Brian was in the background, but I could hear Melanie yelling at someone. She then got on the phone with me and proceeded to cuss me out, harass me, and state that, you know, we should get into a physical altercation.
Did she ever state her name, or is this just being based on other information or assumptions?
Yes, she did state her name. She stated that this is Melanie and that I'm a coward because I don't want to physically fight her and to stay away from Brian, to not speak with him. I should only speak with him if it's about our child. She was just going on and on and on. And I
Okay.
eventually then stepped in and just said, Melanie, please stop contacting me from Brian's phone. You're already violating the PPO order. And I hung up on her.
So you said that you and Brian never fight, yet you were no longer in a relationship?
Correct. We were not in a relationship at this time.
Okay, but would it be untrue then that you never fought or never had any issues?
Brian and I never had any issues, no. We had separated because of, you know, things just not working out personally between us, but we are very cordial and have a great relationship for our daughter.
Okay. And you don't recall what date this alleged phone call took place on?
I believe it was, I'm going based off of memory here. I believe it was late October, maybe early November.
Okay. I have nothing further.
Any redirect, Mr. Jackson?
No, thank you, Your Honor.
Very good. And I don't have any additional questions. Thank you, Ms. Fournier. You may step down from the witness stand. Any additional witnesses or evidence, Mr. Jackson?
No, Your Honor.
Any witnesses or evidence to present, Mr. Byer?
Yes, Your Honor.
Very
I
well.
would call Ms. Melanie Gonzalez.
Very well, Ms. Gonzalez, would you raise your right hand? Do you solemnly, what, are you going to unmute? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I swear.
Thank you. You may proceed, Mr. Byer.
Thank you. Mr. Gonzalez, did you ever contact Ms. Fournier?
Yes, sir.
Fournier?
Prior to the PPO on September 28th. Yes, sir. It
Okay,
was in response to a video.
but you never contacted her after October 1st
No, sir.
by text or by telephone?
No, sir.
Okay. Did you ever respond to her or knowingly respond to her when she may have reached out to you?
No, sir.
Okay. I have nothing further, Your Honor.
Mr. Jackson?
Thank you, Your Honor.
Excuse me, Judge, we lost the petitioner.
Oh,
Can I ask a question real quick to Jeremy? I just want to know if you're receiving my text.
I am not.
Because it was about a witness. The one I talked to you about.
No, I don't have any text from you.
Does that phone number I called you on receive text?
No, I'll text you from the one you can text me on.
Okay, thank you.
We have a Nicole Watson. in the waiting room? Is that the person you're speaking of, Ms. Gonzalez?
No, it's another staff member,
Okay.
George. He was.
And I
We are
believe,
back on the
sorry, go ahead, Lisa.
We are back in the record in the case of Fournier versus Gonzalez, case number 24-09587PH.
And Mr. Jackson, I believe you were cross-examining Ms. Gonzalez.
Thank you, Your Honor. Ms. Gonzalez, I think you were asked two different questions. I think you were asked whether or not you ever texted her or whether or not you ever knowingly texted her. I guess my question is, did you ever, since October 1st of 2024, send a text message to the petitioner?
No, sir.
Never on accident did you do that?
No, sir. And I've had my number for 10 years already. Same number.
You didn't text her thinking you were texting somebody else?
No, sir.
Okay. Your Honor, I have no further questions.
Ms. Gonzalez, did you ever call or text utilizing Brian's phone?
No, sir. I have been present when Brian has talked to her, but I have never called her personally myself.
And you never texted her from that phone?
No, sir.
Okay, all right. Those are all of my questions. Any follow-ups, Mr. Byer?
No, Your Honor.
And Mr. Jackson?
Just one, Your Honor. When you were present and Brian called her, did you ever get on the phone or engage in conversation with the petitioner?
No, sir. The only time I ever heard from her, it wasn't even her. It was somebody else. And they were speaking Spanish. Leah is white. She doesn't speak Spanish at all.
Okay. But so when you were present for calls between Brian and the petitioner, you never engaged in any of that conversation?
No, only to Brian, because Brian was saying she was I have text messages of Brian saying how she was stalking him and harassing both of us. That's why he got on my phone plan.
Nothing further, Your Honor. Thank you.
Very good. Any follow-ups, Mr. Byer?
No, Your Honor.
All right, then thank you, Ms. Gonzalez. You may step down from the witness stand. Any additional witnesses or evidence to present at this time, Mr. Byer?
No, Your Honor.
Very good. Then I believe you then have rested and we'll move to closing arguments, Mr. Jackson.
Your Honor, I believe the court has received testimony. If it believes that the prosecution has met its burden of beyond a reasonable doubt, I'd ask the court find that respondent has violated the PPO.
Very good. And Mr. Byer?
Yes, Your Honor. At this time, there's been no presentation of any text messages that would indicate that Ms. Gonzalez messaged Ms. Fournier at any time. Also, the only evidence you have is the testimony from each party. Ms. Gonzalez has denied ever calling or texting her or engaging in a conversation with her. I feel that there's a lack of proofs in this matter to show any type of PPO violation and would ask the court to dismiss the allegations.
Very well. Thank you, gentlemen. Well, I have heard the testimony today, and I will note for the record, that is all I have in front of me. I do have the original text messages that the PPO was based upon, dating from 2024. However, I have not received any additional text messages, even though Ms. Fournier indicates that she has them and perhaps has submitted them to the PPO office. Unfortunately, they did not make it into the court file along with the allegations of a violation of the protective order. And the allegation pressed by the prosecutor today was that Ms. Gonzalez utilized Brian's phone. Brian's a male that both women have been in a relationship with at different times, in order to text and or call the petitioner, Ms. Fournier. And Ms. Fournier says that she knows specifically the texts were from Ms. Gonzalez because She recognized the language and diction in those texts as being different and longer than Brian would normally send to her, and also that Brian doesn't speak to her in the manner that the text did. And additionally, there was testimony about at least one call where the number was used to call her and engage in a conversation where presumably she would recognize Ms. Gonzalez's voice. However, I can't find that evidence rises to the level required to find guilt of a violation of the protective order, and that standard is beyond a reasonable doubt because if Ms. Gonzalez were to be convicted of the violation, she does as she knows, is at a risk of spending time in the Kent County Jail. And I simply can't find that. It's one person's word against another. I don't have the texts themselves in front of me to evaluate the language used in the texts, nor for that matter to compare them with any texts of Brian's to see if indeed they really are that different. That would leave us with the one voice call. And of course, this, someone else could have grabbed Miss Gonzalez's phone and texted for whatever reason. Now, Miss Fournier says, well, obviously that she's the only one that has this disagreement with me or, hostility towards me, so it must be her. But that's not enough to reach that standard of beyond a reasonable doubt. It has to be clear and unmistakable evidence that it is her texting. In the case of the one alleged voice call, that was contested by Ms. Gonzalez. And further, there wasn't certainty as to what the date and time of that call were. Ms. Fournier did testify she was quite certain it was after the PPO was granted. However, that certainty was not provided. And of course, in the case of one call, particularly one call like that, where the conversation went back and forth, and appeared to be coming from Brian, that, of course, that was simply a misunderstanding, or that Brian initiated the call and somehow Ms. Gonzalez's voice got on there because they were in the same room or something of that nature, i.e. not an intentional contact. Now, I will note that if Brian's talking on the phone and Ms. Gonzalez, who is to have no communication by the orders, was to yell over Brian or speak into a void of the conversation or whatever in an effort to communicate with Ms. Fournier, she could be violating the PPO in that context. However, there's not enough evidence before the court today to make that conclusion beyond a reasonable doubt. So I am going to deny the allegation and dismiss the alleged violations of the PPO at this time. However, I will note that the PPO does remain in place with the expiration date set by the court. Anything else we need to make a record of, Mr. Jackson?
I don't believe so, Your Honor.
Mr. Byer?
No, Your Honor.
Ms. Gonzalez, I did see you raise your hand. Would you like some additional time with counsel?
Yes, I had a request. We talked about it. Because here in the state of Michigan, a person who has a PPO against you can still harass you, and that is this case. So how do I get one? How do we have one together? So nobody is contacting each other and this doesn't happen again. Because I want this person out of my life forever. Both of them.
One thing, you can't have a reciprocal protective order in the state of Michigan. That is, I can't grant one that says what's good for the goose is good for the gander. They both have to have their own separate factual basis to stand on. Of course, if you think there is a basis for you to obtain a PPO, separate from what we've talked about today, if Ms. Fournier appears to be making the initiative and making unwanted, harassing or threatening contact with you,
He's using fake numbers.
You're right. You can be heard separately.
Yeah. Okay. Thank you.
Thank you.
Thank you, Your Honor.
Well, Ms. Fournier has her hand up. Ms. Fournier, did you have a question as well?
Yes, Your Honor. Since the PPO office failed to provide additional documents stating the timestamps of the text messages and what the text messages stated, just to clarify, there wouldn't be a way to appeal that or extend this court case? I don't.
If you can establish that you did submit them to the PPO office, what you could do is you could submit what's called a motion for reconsideration.
Okay.
In that I didn't get to view all the evidence, and that you could put all that together in a written submission to me. You only have a short time to do that, however. The
Okay.
limit on reconsideration and to get it filed is 14 days.
Okay. Yep, that's fine. I'm sorry, but this has been going on for way too long, and I don't want anything to do with her, nor have I ever spoke to her. She's a pathological liar, and she does nothing but cause issues. I want her to stay far away from me and my family.
All
And
right. Well, it sounds like the feeling's mutual. Of course, the issue here is this Brian guy that you're both involved with, and he's going to be a continuing flashpoint. So resubmit that evidence with a motion for reconsideration, and I'll consider it at that time. In the meantime, it sounds like you're both best served by the PPO orders keeping a distance from each other. Thank you.
There you go.
All right, everyone, I'm going to go ahead and call. Coryell County calls number CVAGO. Oh, that's different. Okay, I guess they switched things around for Trent. Anyway, this is CVAGO 233972. And this is in the interest of Costas minor child. Non-custodial party being Ricardo Costas, custodial party being Danielle Hutton. And this matters before the court on a motion to confirm arrearages. The court will take judicial notice of the court file. Note for the record that both parties are present. And at this time, I'll ask the state for an opening to tell the court what the state is requesting we do here today, whether or not it's going to be a final or some type of temp. And let's see. I see a waiver of service from Mr. Costas. Was mom served on this one? I don't seem to have the citation. Let's see. Did she sign up?
I'm pretty sure the answer is yes, Your
Oh,
Honor.
yeah, I found it. I'm sorry. It was hiding behind something. Yes, so the court will note that both parties were served. This is let's see, this looks like this may have been from last year. Yeah, it's 2024. Anyway, so they're definitely before the court properly at this time. So I'll ask the state to tell the court what the state's requesting and whether or not we're going to do this as a final or attempt. Thank you.
Thank you, Your Honor. So I'll give the court the request first, and then I think there's some backstory too that I think at least Mr. Costas is probably going to ask the court to take into consideration. So requesting a final order, my understanding is that Ms. Hutton wants to forgive $35,000 in arrears. Presently, I show arrears of $56,196.45, and that's as of May 31, 2025. We don't have a more recent date because of our recent software updates, but so my understanding is she's wanting to forgive $35,000 of that, which would be a remaining amount of $21,196.45. And the state has no objection to that. So that's the request from the state, and then and would also ask the court to order some sort of repayment to whatever the court thinks is fair. So here's the rest of the story, Your Honor. My understanding is that the parties had an agreement between them. I don't want to say that the state was a party to this agreement, although I think we attempted to facilitate the agreement. So the agreement was that she would pay $35,000 and he would pay $35,000 and she would forgive the balance of the arrears. My understanding is upon further reflection, she forgives it's fair to go dollar for dollar. Mr. Costas, I believe, will testify to the court that I think he's going to raise an equitable issue. That being that there is an agreement between the two of them. My position is legally that was not enforceable because we're talking about old consideration for a new agreement. The old consideration being the child support that was already owed, but I'll defer to the court there. I think what he's going to tell the court is that he sold his barbershop business in order to pay this $35,000. And he basically cashed out in order to hold up his end of at least this new bargain. And I think as far as the other equitable side of this, he's a veteran of Iraq. I believe he'll tell the court that he had some real struggles when he got back, and that's part of the reason why the arrears got so out of hand. Anyway, but that's what I have. So I believe the correct legal conclusion is to forgive the $35,000 and confirm the $21,196.45. But I don't maintain to be an expert in equity. So I'll leave the rest of that with the court.
Okay, you kind of lost me on this one. All right. The mother has received the payment for $35,000, or she's just forgiving $35,000?
She's received 35,000 in payments, Your Honor.
Oh, okay, okay. All right then.
It paid through the state disbursement unit, so that's, and we've confirmed that.
All right, and the money's been dispersed and is not on hold, correct?
Correct, Your Honor.
All right then. All right, well, now the court's back from delay. The court will recall Coryell County calls number 02. Okay, that's okay. 02-33,972, and that's in the interest of Costas minor child, or Costas minor child. Anyway, the state has just completed their opening statement. I understand some funds have been transferred, and I need to get some details on what the circumstances were, whether or not there was a writing, whether or not there were other items. So let's go ahead and let me get the parties sworn in, and let's get the testimony, and let's see what the court's going to be able to do here at this time. So at this time, I want both parties to unmute themselves if you're muted, and raise your right hands, and I'm going to get you under oath. Thank you. Do you both solemnly swear or affirm the testimony you're going to give here today is the truth, the whole truth, and nothing but the truth, so help you?
I do.
I swear.
All right, you're both officially on oath at this time, so I'll go ahead and ask the state to call you as individual witnesses. And Mr. Diamond, if there's anything else you wanted to do to complete the opening, you can do so at this time, sir. Thank you.
Well, I guess maybe if I could just add, I mean, the court already heard that he's a veteran, so I imagine the court will waive court costs for Mr. Costas.
Yeah, that's not going to be a problem. I always say that for the end, but that's not a problem. Thank you. All right, you ready to call your first witness then? Thank you.
Thank you, Your Honor. I'll call Ms. Hutton. Ma'am, will you state your full name, please?
Danielle Leanne Hutton.
It looks like your name is misspelled on the... Sorry, that was me. All right, so let's talk about what we're here to do today. So my understanding is that your desire is to forgive 35,000 of the arrears that Mr. Costas owes you. Is that correct?
Yes, sir.
Okay. So let's talk about the and I need to ask, has anybody pressured or coerced you into making that release?
No.
Okay. All right, so let's talk about the backstory. So I think you probably heard me tell the court that there was some sort of an agreement that he would pay 35,000 and you would forgive the rest of it. Was that originally your understanding?
So originally I wanted 45,000. And then he kept saying he couldn't do that. He had said he could do 40. And then he came back and said he could do 35, and he just kept texting or calling my son, like doing all kinds of things. So I would accept the 35 and forgive the rest. But I never felt comfortable forgiving all of that. And him only paying 35. But I felt like if I didn't say, yes, I'll take your money, I would have gotten nothing.
Okay. And I'll try to keep this brief, but there is an equitable side to this. Tell me if I understand it correctly. Your position is that Mr. Costas did very little to help you raise y'all's child.
He did nothing to help me raise my child. Absolutely nothing.
Okay, so not around, not physically present.
No, I had my son by myself. I raised my son by myself. He didn't buy clothes, shoes, no phone calls. He did nothing.
Okay. All right, and again, I'm not. I don't have I've told you before. I don't have a huge interest in this thing. But the court's probably going to want to know, so I'll ask you now. You could understand how one could argue that it's not a great look that even if he didn't hold up his end of being a father, that you said you were going to forgive the whole thing, and now you're only forgiving most of it. You can see how that's not necessarily a great look.
I could see how it's not a great look, but I feel like I was very pressured into saying the 35. Like even now he would text me today nonstop.
Okay. Yeah, and I think legally you probably have an argument there, but
Okay, here's the deal, Mr. Diamond. Also, going forward, I'm getting ready to stop the texting between the two of these. Okay, yeah. Here's the deal, folks. That's interfering, sir. What you may have been doing today may be criminal, and I don't want anyone to think about going there. But you're not allowed to interfere with a witness or with testimony that a witness is going to give in a court of law. So that's very problematic. So at this point, going forward, sir, do not do that any further. Otherwise, I will have to turn this over to the appropriate district attorney's office. So I just want to get everybody on the line on this, but let's not do anything behind the scenes because it could be considered criminal. You may proceed.
I'll pass a witness, Your Honor.
All right, now, how did the money come through the state disbursement unit, Mr. Dunn?
Yes, Your Honor.
Okay, so so it came through the state disbursement unit, so there's no reason for the forgiveness. It's automatically done. He's automatically got that credit, correct?
Right, but I want to match him dollar for dollar.
Right. He owed like 81 something, Your Honor. He's paid 35,000 against that 81 that he owed. So she's wanting to forgive 35,000. So that's why the request would be to take
an additional 35,000.
No. He's let me if I could put it this way, Your Honor. So 81 something is what he owed. He paid 35,000. So presently on paper, he shows an arrears of about 56 and some change. She desires to forgive 35,000 of that 56, which would leave a balance of 21 and some change.
Okay.
And then I think he's going to tell the court why he doesn't find that equitable.
Well, I'm going to tell her. I'll get ready to give him some bad. Y'all got, ma'am, do you have everything in writing?
No.
Okay. All right. Thank you. All right. I'll let you call your next witness.
Thank you, Your Honor.
Thank you.
All right. I'll call Mr. Costas. Sir, will you state your full name, please?
My name is Ricardo Antonio Costas.
And my understanding is you're a veteran of Iraq, Mr. Costas?
Yes, sir.
Okay. So let's talk about this case. That was your understanding as well, that you would pay 35,000 and the rest would be forgiven?
Yeah, that's what we talked about.
Yes, sir. And so tell the court what you did in order to raise the 35,000.
Well, I sold my business, but I told her that I was going to sell my business, the barbershop, so I could give the money to her. And I had $10,000 saved up, and I gave it to her. And I asked my dad $5,000, and that's what I came up with, the $35,000.
Okay. Where does that leave you at financially, having paid all that money?
I got about $2,000 in my bank account right now.
Okay. What kind of, I guess what I'm really asking, so selling your business, what does that do to your earning potential going forward?
Well,
And your
I'm
son has
still
grown,
working.
so I'm not asking that to try to change your child support. This is more of an equitable consideration.
Yeah, I understand. I mean, I could pay little by little, but I mean, we reached an agreement, and now, I mean, we talked about it, and now she want more money, and then she told me she want 45, and now she still want more. I don't know where we're going with this. I mean, I understand I wasn't there for the kid. I wasn't in a good place. When I came back from Iraq, I had some issues. I even got wrongfully kicked out of the army, and then I just got on my feet. I mean, I got my discharge changed, and I'm trying to do the right thing. I even bring my son last year over here, and I wanted to go visit this
Okay,
year.
Mr. Mott, I hate to cut you off, sir, but now you're going way past the question that was asked. So again, sir, you need to listen to the question that the attorney asked and just answer that question at this time. Thank you.
Okay.
So I think, and you've told the court most of it, you understand how this, in my opinion, this is not really a great look for either of you. Because on the one hand, she said she was going to do something, and now she's wanting to do something a little significantly different. But on the other hand, it's not necessarily a great look for you either, because you owed her $80-something thousand, and even though
And
she
I
pulled the
owed
car,
up to that, and I know that.
yes, sir. So I guess the question is, it's really an open-ended question. You understand, though, that I think what she would probably contend is that you're still getting a pretty good deal here because you owed $80-something thousand. You paid 35, and you're going to come away only owing, 21,000. assuming the court does what's being requested. You understand how it could be argued that that's even though the process was crooked, that's a fair result.
I understand. Yeah.
All right. So how do you respond to that?
Well, I mean, well, I don't understand the question.
Well, I mean, really, it's she didn't do what she,
Okay, I get what they're doing, sir. And again, any argument, Mr. Diamond, this is going to fall down to these folks didn't have a writing. I mean, this, anything they did, any side deals they made, anything on the side, it's under Texas law, I'm not going to be able to. That's unenforceable. It really is.
Yes, sir.
I'll double check. I haven't had to look at something like this in a long time. But I'm pretty sure that that's why I kept asking you folks, y'all got something in writing, a contract or something one way or the other that says that this is what's going to happen. Because when you're dealing with a certain above a certain amount of money, the state of Texas, there's a thing out there called the state. Well, it's universal. It's called the statute of frauds that requires something like this to be in writing, at least with if not notarized, at least with the party signing off on it as an agreement. So again, we're doing that much money, and the fact that the money was owed, I don't think I can enforce anything on Mr. Costas' side. Again, like I said, I hadn't had to look at this for a while, and I'm gonna do due diligence and do some legal research on this one, because I'm pretty sure this has happened a lot more than once before, and I'll see what the different courts have said. But right now, sir, I based on my initial understanding of everything, there's probably not a darn thing I can do differently than give you credit for the $35,000 that went in. And if Mom wants to, in addition to that, give you further credit, that's something that she can do voluntarily. But I'll get the state to confirm that she wants to do that and take it down to that $21,000 again through her testimony. But that might be the only deal you're going to be able to get out of this, there, sir, because y'all didn't you didn't do this with a writing, and you didn't do it through lawyers, which would have made sure that everything was, all the I's were dotted and all the T's were crossed, and that's just the way it's going to probably fall. But again, I haven't had to look at something like this in a while. I hadn't read any case law on this one in a while, so I'm going to do my own, like I say, due diligence, look it up, double check everything. But the best I'll probably be able to do, sir, is give you the credit for the $35,000 that you paid. If Mom wants to voluntarily dismiss another amount and take it down to $21,000 owed, sir, then that may be that's about as far as I might be able to go on this one. But again, I'll do my own research on this one and confirm that the initial finding that I'm looking at making on this one. So at this time, I'm going to let the state recall either witness, and I want to confirm that Mom still wants to forgive the amount and take the judgment amount down to $21,000. And I want to take this one under advisement and reset this one for next week on one of my journal dockets, and go ahead and make a final ruling to confirm and deny the request of both parties.
Thank you, Your Honor. So I'll recall Ms. Hutton. Can you go ahead and turn off your mic or turn on your microphone, Ms. Hutton?
Yes, sir.
Okay, so again, it's final answer. You want to forgive the $35,000 and be done with this? Is that my understanding?
Yes, sir.
Okay, thank you, ma'am. I'll pass a witness, Your Honor. So,
ma'am, you understand that you're agreeing that that you're forgiving everything, and no matter what the bottom line is, that $21,196.45 is possibly going to be what the court finds is the amount that's still owed, and I'll still have to come up with a repayment plan on that. Is
yes,
that what
sir.
You're saying? All right. All right, Mr. Costas.
Yes, sir.
Anything else you want to tell me at this time, sir? Again, I understand the equitable arguments, but the law is kind of clear. I wouldn't buy a car for $80,000 and not put it in writing somehow. Okay, it's just got to be in writing, sir. So is there anything else you can tell the court, or anything else you're requesting, sir?
No, I'm okay. Thank you.
All right, then, guys. Like I said, I'll double check, and if I find out there's an equitable reason to do this, I'll reset this matter for a special setting, and I might have to bring y'all in live on this one, but I'll probably consider it on Zoom. And we'll take this hearing for back up. But again, based on the the statute of frauds and the Texas, unless the state of Texas has done away with the statute of frauds, which I doubt, then without a writing, that's any agreement you made would be 100% unenforceable. And I'll confirm that, and whether or not there's something that's been carved out under family law that lets me do something different. So at this time, folks, I'm looking at doing a reset. Y'all don't have to appear. I'll make it on the for the reset, because next week's a big holiday week, so people are traveling. But I have court I got a live docket next Wednesday. Next Tuesday, I've got my Zoom docket. So I'm gonna reset this for July 1 at 9 a.m. on the general docket, but only for the purposes of ruling. And if the ruling is that there is something that could be carved out, y'all will get that ruling in writing, and you will get a notice of a special setting, so I can have a final hearing on this, where you two are the only hearing I have during that 1 hour, 2 hour time frame.
Okay.
All right. So again, every now and then, this is kind of interesting. Every now and then judges want to see what the law is anyway, because but I'll go ahead and do that reset, and but y'all can be here on the 1st if you want, but you don't have to be. So one final time, any questions, Mr. Costas?
No, thank you, Your Honor.
Anything? Any questions, Ms. Hutton?
No.
All right, Mr. Diamond. Anything else from the other witness?
Your Honor, if I could ask him to stick around and sign the reset, because we're right up against the time to get the reset file, get the notice out. It'd be a lot cleaner if I could get signatures on a reset.
Right, because it's 3-day notice and everything. This is a Thursday. All right, folks. I need to ask y'all to hang around and sign off on this. This confirm that y'all got it. It's legal mumbo jumbo, but it'll mean that I actually can have that hearing or take this back up next Tuesday, instead of kicking it out another week after that because of the holiday. All right.
Okay.
All right, thank you, folks. We're off the record, and everybody be safe out there and have a safe 4th of July. All right, thank you.
You too.
Thank you, Your Honor.
All right, CSC South Hill Realty versus Alexis Najera. Alexis, come on up. All right, Alexis is present. I'll hear from you.
Me first, sir? Okay. So Alexis rent is $850, and it is a full subsidy as well. Her portion is nothing. I just gained possession of this property middle of April. We've had quite a few incidents with her. Here is one incident report. Well, there's quite a few. We do also have a written statement from a person that she pointed at, and we also have pictures here as well. This is from him. This is another statement, and these are all there. It refers back to that other police report.
On. All right, I'll hear from you. Tell me what's going on.
The incidents are false. I have the actual police reports, and on one of them, she's evicting me for pointing the rifle at him, but it's an incident. They have it with incident with in the report. It's not a rifle, it's not even a BB gun. I never did that to anybody. And then
It's not a rifle, it's not a, what is it?
Just a BB gun, sir, and they said I was pointing it at them and everything like that, but in the police report, they came and they talked to both of us, and it was his fault. He had loose pet bulls everywhere. That's what.
He had what?
He had loose pet bulls. Loose pet bulls. He had loose pet bulls. That's why we got in the altercation.
Loose
pit bulls.
Loose pit bulls.
Yes, sir.
So who was that person?
The person that he lived in 502. I guess the person she got the sign form.
All right, so that's one. What about the others?
She also said that I assaulted her at one point, and that's false. I told him, I was like, I didn't assault nobody. I did.
Well, what do you do for a living?
I go, what do you mean, what do I do for a living?
Oh, yeah, do you work? What?
No, sir, I was, yes, sir, I did work full time, but I was, domestic violence, that's why I get help, because they're trying to help me.
Yeah, but, okay, so where are you working?
I'm going to school.
Oh, you,
Goodwill Careers
all right.
downtown in San Antonio. That's what I do. I have my, and then I have this thing from the city where I call them to fix my stuff and it takes them like, they don't fix it. I even have, she has me and then so I have to call the city and they have to come make sure they fix it because they're not fixing it for me.
Well, that's not before the court. What's before the court is whether or not you have been violating.
No, and then I'm not violating anything.
Well,
And then she has me under a lease violation for my dog, but in my lease, it's getting paid for. It's just not able to get, she doesn't have it on there, like the name's not on there. It's just, it is getting paid for, but she said that I have a unauthorized dog.
I have a copy of the lease. If
does she have a dog?
She does, yes, sir.
Well, is it paid?
No, I can give you the copy if you like.
I have the lease on my phone.
All right. Well, the lease, the lease that you have provide for the dog?
Yes, sir. But it's not on there because when I email her or call her, like she doesn't answer, she doesn't pick up, she doesn't take any of my emails. I even been requesting like for my parking pass to be delivered in the mail because we've been having problems, or on my door and it hasn't been delivered since any of these
Right now, we only require parking passes for people that have covered reserved spots. She does not have a covered reserved spot, so we have not done that phase yet to enforce the open parking spot. So at this point, it's not necessary for her to have one. And I've explained that to her as well too. And that was, I gave you one of the case numbers in there as well too. That was explained to her. It got really escalated in the office. I asked her to leave. She refused to leave. Once I walked outside, I opened the door, I started walking outside. She followed me just continuously. I started walking back in backwards and tried to close the door, pushed me back. I pushed the door back closed. I'm there to make it safe for people that I treat this property as if I lived there and I want to make it safe. There's a lot of things that were done with the prior manager, and I'm having to take a lot of action towards it right now.
All right, anything further? What's the address of the property?
So we have 3 different addresses. This particular one that's in question is Quig, but the office where we're at is Lasses.
All right, having heard the evidence of the judgment of the court, the plaintiff had possession of the premises. This is not a court of record. You have an absolute right to appeal the court's decision. All right, there you go. I suggested you visit with is the city here after all? Gilbert? No, Judge. There you are. All right.
Thank you, Your Honor.
Right.
Appreciate it. Have a good weekend.
See if you can provide her with some information with respect to rental relocation information.
Sir, she didn't even give me 30 days to vacate when she did. Under the CARES Act, it's supposed to give me.
Is it a CARES Act property?
We are not. Yeah, she is. She's with Sam Ministries. I gave it to a lawyer and I.
Okay, all right. Well, visit with the lawyer.
I did.
All right, well, where is the lawyer?
No, it was the St. Mary's lawyer that they referred.
All right, okay, well, you should go back and visit with them so they can help you.
Okay, so what do I do?
Well, a judgment's been entered. You have an absolute right to appeal the court's decision. You have 5 days to appeal. So you can get the appeal information at the front desk there.
5 days to move out, 5 days to appeal.
Okay.
All right, Roxanne Gonzalez. You need to show your video, please. All right. All right. Could you say something so we can see if we can hear you?
Yes, fine. Hello.
Oh, all right. So we have a violation report saying that you are still drinking alcohol. You're not allowed to drink alcohol. Do you understand?
Yes, ma'am.
So what are you doing to help maintain your sobriety? No, I cannot hear you. You need to stay still, stop moving around, because when you move around, we can't hear you. So what are you doing to maintain your sobriety?
Well, I'm just not gonna drink because I usually don't drink. It was just my sister's birthday, so it was a family function, and I won't drink no more. And I don't drink. It was just
No, you do drink. And let me just tell you why I know you drink. Allegedly, this case has been indicted because you were driving while intoxicated with a child under 15. So allegedly, that means that you were drinking alcohol. That's why it's driving while intoxicated. You're on bond for driving while intoxicated with a child under 15, which you think would be a wake-up call for you not to drink alcohol, and you're still using excuses to drink. So what I'm telling you is you are not allowed to drink while you are on bond. Now, what I can do is I can issue a warrant for your arrest. And if you drink, it'll be you making alcohol at the Bexar County Jail, which my understanding you can do with orange pills after you let it mold. So that will be the only way that you'll be getting your alcohol. You understand? So I am going to follow through on the recommendation from the state. You're going to continue with ignition interlock. You are going to take the alcohol awareness course, and you're going to do 30 sober meetings in 30 days. If you violate that, a motion is going to be sent to me. It's going to be another violation report. You're going to be required to appear in court and answer for it. Do you understand?
yes, ma'am.
All right. Is there anything else?
No, Your Honor.
All right. So Ms. Ferguson, on this case, recall it back for, they had on the 30th, it was going to be a blood discovery.
We're still waiting on the blood evidence.
All right, Norma, if you'll recall this back for the 4th week in July, please. The 21st. All right, so you're going to be back here on July 21st.
Judge, I'm on vacation that week. I'll be
Okay.
back the following week.
All right, let me see. Just 1 second. Oh, where are you going? Are you just going to be a staycation?
No, I'm taking the kids to Florida, the wife and kids to Florida.
Oh, that's going to be awesome. So you want to do it the week of the 28th? Or you want to do it the week of the 14th?
Of August.
July.
I'll get back like August 1st, Judge.
All right, so do you want to do it the week of July 14th? Is that good or no?
No, we're going a long time.
Oh, okay. All right, Norma,
Yeah,
set this for the week of August 1st. I'm sorry, August 4th.
I can do the 4th.
All right, you're going to be back on August 4th. And state that's the final discovery. So the blood discovery needs to be given to him. And if some reason they don't have the blood discovery, then they need to be here to explain why they don't have it. Criminal Trial Division.
Can I be excused, Your Honor?
Yes. Hi. Hi.
Sorry.
That's okay. On Roxanne Gonzalez, we've been waiting for a blood discovery since February. So it's being recalled for August 4th. If for some reason the blood discovery is not in at that time, then someone from that department needs to be down here to explain why it's not completed. Oh, you have it? Ah, so have you tendered an offer to defense?
Yeah.
All right, tender an offer to defense, and defense, then that will be your plea deadline date, August 4th.
This is something, apparently I did.
Judge, he gave me an offer.
All right, your plea deadline date is going to be August 4th. After that, you're going to have a jury trial date. All right, you're excused.
Okay, thank you.
You're welcome.
Ms. Conley, can you start your video and unmute yourself, please? Calling the case number of SP 4519123. This is the state of Michigan versus Mina Jenna Conley. Your appearance, please. That means tell me your name, ma'am.
Manaya Janae Conley.
Okay, and this is the date and time set for an informal hearing. It was set for 9:31. It's now 9:49. The officer has failed to appear. Therefore, this matter will be dismissed without prejudice. Any objection?
No.
Okay, but before that, ma'am, it's just not always going to be that easy because I would like to note two things. You're driving at a disgusting rate in a construction zone. You are putting your life and that of construction workers in danger, driving your car in such a manner. Okay? When I read this remark that says you are going 81 in a construction zone, that sends me, okay? There is no reason in life, and you are not that important, for you to be driving so recklessly and selfishly on the road. And then I look at the ticket, and the trooper gave you a deal and wrote you a ticket for 5 over, which was a gift, right?
Right.
Because 81 in a construction zone, certainly if I do the math, is not 5 miles over the speed limit. And instead of taking responsibility for that and taking the loss and taking the break from the officer, you requested an informal hearing on it. And the break for you today is the trooper did not appear, so the ticket will be dismissed. But all that shows me, the court, is the type of person and driver you are. That you would drive in a construction zone where there are workers. Don't roll your eyes at me. Don't roll your eyes at me. And get a break at the road from the trooper. And instead of being gracious and responsible, you pushed for even more consideration. And you get that break today on a technicality because the trooper didn't appear. But you better think long and hard about yourself. If you roll your eyes again, I'm going to set this for another hearing.
I'm looking up. I'm looking in the background, never roll
Okay,
my
well, I would like you to look at me. There's no reason to be looking up.
Okay.
Show some respect and stop being such a selfish driver. And if you can't handle the responsibility of driving and the workers on the road, do everyone a favor and hang up the keys. Those men and women working out there are risking their lives. And the fact that you got such a break on the road and pushed it for a hearing today shows me that you think there are no consequences to your actions and you should just be excused for your selfish behavior. Learn that you exist with other people in this community and you are not important. You are not important enough to be driving and disregarding the other people and workers on the road. It is not about you. Slow down, be aware, and if you cannot be responsible enough, then don't drive because it's a privilege. Are we clear?
Yes.
Okay, you may leave the Zoom.
Okay, so the first one with Judge Rossi, I don't understand where his head was at because that woman was actively harassing her rival while on Zoom, making faces. She would never be allowed to do that in court. She should not be allowed to do that on Zoom. So, in my opinion, she should have been given a contempt right there for her faces because that was inappropriate. But he never called her on it. He never did anything. And then Judge Nelson, I find it also very inappropriate for anyone to roll their eyes when a veteran has trouble or talks about the trouble they had coming back to this country after they've been in a war zone. I just think that is completely uncalled for and wrong. We lose veterans every 17 minutes to their own hand because of the things that happened over there. So my heart goes out to veterans, always, always. And I can believe that he had trouble. I really can. I mean, when he was over there, people were trying to end him. Everywhere he went, they were trying to end him, and you didn't know who they were that were going to try to do that. So, and then Judge Tavera, that woman just lied through her teeth. And if you don't pay for things, if you don't pay for your own things, you don't take care of them. So I think they're best to get somebody like that out. Get someone that actually pays for their own life. And then Judge Boyd was just classic Judge Boyd. And then the woman filling in for Judge Chisholm, I applaud that because I worked in construction. I'm a civil engineer. I worked on bridges. I built bridges. I was on site not 24 hours a day, but at times. But I was on site all the time, working right next to traffic, shooting grade, painting out lines, whatever. And the drivers sometimes would throw stuff at us. They were awful. And, we were just there doing a job. But people traveling public are really vicious to construction workers at times. So I applaud her giving that girl a, stern talking to. So anyway, thank you guys so much for watching. Sorry this was so late, but thank you. And I will see you another time.